An agreement in restraint of trade restrict a person's ability to practice a profession, trade, or business. This normally occurs in two types of situation, which is the first one, an employee who upon leaving his employment agrees not to compete with his employer by setting up a similar business or joining a rival company. And second, a seller of a business with goodwill agrees not to carry on a similar business to compete with the purchaser of the business. To be valid, agreements must be reasonable for both parties and in the public interest. According to Section 28 of the Contract Act 1950, any agreement that prohibits someone from engaging in a lawful profession, trade, or business is void. However, there are three exceptions to Section 28 of Contract Act 1950, which are agreements involving the sale of a business goodwill, partners prior to dissolution, and the continuation of the partnership. Agreements that meet any of these exceptions will be upheld by the court. Some key points should be made about Section 28 of the Contract Act. First, the position in Section 28 differs from the common law. Under Section 28, all agreements in restraint of trade are void to the extent unless one of the three exceptions applies. Second, unlike in the common law, there is no overall test on reasonableness, with the exception of the limited test of reasonableness used to determine local limits in exception 2 and 3. Section 28 of the Contract Act states that an agreement is to that extent void if it is based on an illegal consideration or object, as opposed to Section 24 of the Act. This means that only the restraint of trade clause is unenforceable, while the remaining provisions of the agreement are valid and binding. In this respect, severance is permitted. In comparison to the common law position, Section 28 of the Contract Act is more restrictive, as all restraints, even if reasonable, are void unless they fall under one of the three exceptions. It also makes no difference whether the restraint is only partial, such as for a limited time or for a specific method.
Malaysia has adopted the similar position in the case of Wigglesworth and Wilson Anthony. The plaintiff is the sole proprietor of Wigglesworth and Company, a law company located in Kota Baru, Kelantan. He is also an advocate and solicitor. The defendant is the sole proprietor of Wilson and Company, a law company located in Kota Baru, Kelantan, and he practices advocacy and solicitorship. The plaintiff firm and the defendant signed a service agreement on September 20, 1962. With effect from December 31, 1963, the plaintiff consented on December 7, 1963 to release the defendant from the conditions and obligations of the mentioned agreement. Clause 8 of the mentioned agreement stated that the defendant could not practice as an advocate or solicitor within a 5-mile radius of Kota Baru town for 2 years following the plaintiff's termination of his engagement without first gaining the plaintiff's written consent. Based on this case, Hashim Chach stated that he doesn't think that English cases are applicable because Contract Ordinance 1950 is not based on English law of contract. It is already clear under Section 28 of Contract Act 1950 that in respect of the three exceptions, every agreement by which anyone is restrained from exercising a lawful profession is to the extent void. The defendant can lawfully practice his profession in Malaya, therefore agreement to restrain him from exercising his lawful profession is void.
Potential legal implications are the results or consequences of being involved in something according to the law. The legal implications of Ms. Tan and Mr. Ahmad's challenge to the validity of the restriction of trade clauses would rely on their circumstances as well as the terms of the clauses. The first situation of Mr. Lim and Ms. Tan, both parties were bound to the contract when Ms. Tan said that she was interested in purchasing the goodwill of Mr. Lim's business. However, Mr. Lim had included a clause that prohibited Ms. Tan from engaging in a similar business within the same city for a period of 5 years after the sale. This type of trade restriction would be void and illicit as stated in Section 28 of the Contracts Act 1950. Section 28 does have an exemption though, and Ms. Tan's case would fall under one of them, which is the saving of agreement not to carry on business of which the goodwill is sold would be similar to Ms. Tan's situation. In that exception, it is stated that one who sells the goodwill of a business may agree with the buyer refraining from carrying on a similar business or specified local limits. This means that the restraint clause of the contract can be used because of this exception clause. Therefore, both the restraint clause and the contract are valid. Mr. Lim would not be subject to any legal implications, and Ms. Tan would not be responsible for any remedies and would just have to abide by the mentioned situation.
The second situation of Mr. Ahmad and Ms. Tan, which they are bound to the contract when Mr. Ahmad signed the agreement, even though Ms. Tan had put a restraint clause to not giving Mr. Ahmad works on a radius of 10 kilometers of the business premises during his employment and 2 years after his elimination. Based on the Section 28 of Contract Act 1950, it says that any agreement that restrains someone from doing something in a profession, trade, or business or any related to those is void to that extent. Also, there is no exception under this section between employers and employees regarding the situation of Mr. Ahmad and Ms. Tan. This shows that the prohibition of not working in 10 kilometers during Mr. Ahmad's employment and 2 years of his termination is void, similar to the section stated. It is also stated in the case of Stanford College Group Sediam Berhad and Raja Abdullah Raja Osman that the defendant entered a contract with the plaintiff that has a restraint clause, which says the defendant was prohibited to work as a teacher or lecturer after 2 years of his termination with the plaintiff. The defendant ended his employment with the plaintiff and became employed by another company. The defendant applied to revoke the injunction that the plaintiff had obtained against him, saying that the term mentioned above was void, since it was a clause in restraint of trade. This case relates with the situation of Mr. Ahmad and Ms. Tan, where the restraint clause made by Ms. Tan to prohibit Mr. Ahmad from working at any competing electronic stores is indeed invalid. Therefore, only the restraint clause is void, but the contract for both parties is still valid. As for the remedies, when Mr. Ahmad decided to continue to work without considering the restraint clause, Ms. Tan could issue an injunction to stop Mr. Ahmad from working. Mr. Ahmad could defend by saying the restraint clause is not valid in the first place, as stated in Section 28 of Contract Act 1950, and by virtue of the case of Stanford College. Mr. Ahmad could request the court to set aside the injunction and let Mr. Ahmad work anywhere without being restricted.
Generally, agreement in restraint of trade is void under Section 28 of the Contract Act 1950 unless it falls under one of the exceptions highlighted by the same sections of the Act. The exceptions highlighted under these sections are agreement related to the sales and goodwill, agreement between partners prior to dissolutions, and agreement during the continuance of a partnership. Thus, any clauses which restrain any trade is void under Section 28 of the Contract Act 1915 unless it falls under the exceptions mentioned. In this case, Mr. Lim includes a clause that prohibits Ms. Tan from engaging in a similar business within the same city for a period of 5 years after the sales. This falls under the first exceptions of Section 28 of the Contract Act 1950. Therefore, Mr. Tan's actions of including the clause is justifiable as the act was done to protect the goodwill sold to Ms. Tan. Therefore, restraint clause is valid and enforceable under Contract Act 1950. However, in the case of Saad Marwi and Chan Huan Hua, the federal court held that a restraint of trade must be reasonable to protect the legitimate interests of a business. This is aligned with the first exception of Section 28 of the Contract Act, which mentioned, provided that such limit appeared to court reasonable, regards being had to the nature of the business. These provisions limit the extent of exception clause by allowing the courts to determine the reasonableness of a restraint clause. Given the facts that the clause is valid, it is advisable for Ms. Tan to renegotiate the durations of the restraint clause to be enforced with Mr. Lim, as the period of 5 years may seem to be excessive. If the renegotiations process fail, the second option is to seek the declaratory judgment from the court to determine the reasonableness of the period of the restraint clause. She may argue that the period of 5 years is excessive, given the nature of the business sold to her. It is up to the court to determine whether the period of time stated in the contract is reasonable or not.
The concept of restraint of trade is a crucial aspect of employment law, designed to balance the interests of businesses in protecting their trade secrets and the rights of individuals to pursue their careers freely. While these clauses aim to safeguard legitimate business interests, they must be reasonable and justifiable to be enforceable. The notable case that focusing on its enforceability on such clause is the Stamford College Group student Sedian Berhad and Raja Abdullah Raja Uthman. Stamford College had included a non-compete clause in the employment agreement of Raja Abdullah Raja Uthman, which is a key academic staff member, which prohibited him from working with any competitor within Malaysia for a period of 2 years after leaving the college. After resigning from Stamford College, Raja Abdullah joined another educational institutions, prompting Stamford College to seek enforcement of the non-compete clause. However, the court set aside the claim made by the plaintiff regarding the restraint of clause that is unreasonable and affected the livelihood of Raja Abdullah as a lecturer. Thus, the clause was declared void. Similar to Mr. Ahmad and Mrs. Tan case, now the contract between them is still valid and enforceable since Mr. Ahmad is still employed under Mrs. Tan. However, the issue may arise once the contract is terminated. As we can see from the situation given above, which Mrs. Tan prohibit Mr. Ahmad from working with any competing electronic stores within a 10-kilometer radius of the business premises and for a period of 2 years after its terminations. The situation that may arise is, what if Mr. Ahmad within the 2 years of terminations facing the difficulty on finding other business far from the prohibited radius and he decided to work at any nearest electronic stores within the radius which he could consider as breaching the clause. There is a possibility for Mrs. Tan on the other side claim an injunction from the court regarding the action of Mr. Ahmad breaching the clause stated. However, Mr. Ahmad can argue the validity of the clause, arguing that particular clause may affect his right to earn a livelihood within the unreasonably 2 years of terminations. As for the court, after hearing on both sides, can make a judgment based on the previous case, which is the Stamford College Group Sedian Berhad and Raja Abdullah Raja Uthman. In this case, the court may decide that the injunction made by Mrs. Tan is set aside and the clause made by her on the contract is void. But this judgment should be applicable in the future once the contract is terminated and Mr. Ahmad having a difficulty to earn his livelihood.